Most every employer knows that when somebody works more than 8 hours in a day or more than 40 hours in a week, they think about this as time and a half. Time and a half of what, though? That's the issue. But if you actually look at the law, it says that overtime in California is 1.5 times the employee's regular rate of pay. If you pay any type of additional compensation, like bonuses or commissions, it's not necessarily 1.5 times their base pay if you pay overtime. If you're doing it wrong, there's no defense. It's not, I didn't know what I was doing, I didn't understand the law. Even if you're off by a couple cents, we're talking 6 figures, 7 figures, or 8 figures, depending on the size of your business. You might think, I don't have a regular rate problem because our bonuses are discretionary. Courts are very, very, very reluctant to call bonuses discretionary. It truly has to be something where the ownership or the management, almost as a whim, decides to give like a spot bonus. Most bonuses, if there's any type of expectation or any type of past practice, will be considered non-discretionary. And you have a potential for a regular rate issue. It's not just a commission system or a flat sum attendance bonus or production bonus. There's all types of sneaky incentive or bonus or compensation systems that courts have found that factor into the regular rate, overtime rate, or the sick leave rate, or the meal or rest period premium rate. So it's really complex. The point is, if you have any other type of compensation besides just their straight pay, you most likely have a regular rate issue and you need an expert. Class action cases for regular rate claims go back 4 years. So think about that. Every employee, current and former, penalties and damages, plus the other side's attorney's fees, plus yours to defend. Regular rate of pay cases start because somebody gets fired. So they go to a lawyer. The lawyers say, I'm so sorry that happened to you. Hey, can you show me one of your pay stubs? Any halfway decent class and PAGA lawyer can look at a pay stub, and even me, I'm pretty bad at math, I can tell you if there's a regular rate violation in 2 minutes. That's how a class and PAGA case starts. And if you did it wrong, like I said, there's no defense. 6, 7, 8, 9 figures, depending on the size of your company. We have collectively handled over 1,200 wage and hour actions, and I can tell you with almost absolute certainty that there are very few payroll providers in California that get it right the first time. Sometimes we've even had to threaten to sue very sophisticated national payroll providers to get them to understand how to do the regular rate of pay. Under new PAGA, which is the revised and reformed PAGA that went into place June 19, 2024, there is an opportunity for employers to protect themselves from future PAGA cases by allowing for the possibility of 85% penalty reduction for employers to do several things. One of those things is conducting a comprehensive audit of their wage and hour policies and practices, and one of those things is a comprehensive payroll audit. And so if you do one of those comprehensive payroll audits, one of those things would be looking for regular rate issues. So hopefully that just gives you just a small glimpse of what I call doing business in a gotcha state. Given the risks involved, you owe it to yourself as a company to potentially mitigate risk to at least have the issue looked at by a team of experts on the regular rate.